Good evening, Captain Retired Matt Edwards here with the next installment of my Facebook Live Observation Post Weekly Update. Now, again, I might do a few items and then talk about some recent phone calls and activity, because I'm kind of triggered, I guess, the last few days about a certain thing that I found. I don't think I talked about last week. But anyway, let's carry on. I'll just say 4 points, and then I'll talk about the latest crusade I'm on. Okay, number 300 actually, in my numbered list that I have listed in my files group, files post, separation and divorce. Now, that's not much to go on, but what I meant about all this stuff is that I've been trying to help veterans who've gone through divorce. No expertise in divorce, but I know a little bit about cases I've read about divorce, and I know a lot about pensions and insurance. For one thing, pensions are not income. For another thing, insurance is not income. Both of these are property. Now, one of the main points that I'd like to make is that it appears to me that the provinces who are responsible for divorce stuff, it seems to me that they have gone from dividing property in divorce to using income. But the problem with that is that, say the Clark versus Clark Supreme Court of Canada case in 1990, it was a divorce case, and the argument before the court was the Canadian Forces Superannuation Act pension or property or income? So they decided it was property, and earlier, back in 1982, the government had introduced the Garnishment, Attachment, and Pension Benefit Division Act, GAPTA. Now, GAPTA allows the government to divide the pension. If someone gets divorced, they're supposed to follow a specific procedure. The specific procedure is to get the court order from the divorce, send it to the Department of Justice, then the Department of Justice sends it to the people making the pension payment, and then the pension gets legally diverted. But what people are doing now in the provinces, at least I believe this is the case from my talking to and corresponding with veterans, is that they ask you what you get, and they require you to pay into the court, and then they avoid this federal Canadian Forces Superannuation Act procedure that's required by law, by federal law. So I'm not saying that someone should get away from any of their obligations, but I'm saying they ought to follow the correct legal procedure. They ought to not include insurance as income, because insurance is insurance money, not income. They ought not to include pensions as income, because it's legally property, and they ought to know that it's property. In fact, one particular case, I don't remember the name of it, but they said you can't divide a pension separated as property and then also make it into an income, figure out how much income it's going to produce, because basically that's double dipping. Now, there are other issues, and one of the main ones that really pisses me off was when they take the Pension Act pension into account. If they take the income replacement benefit into account. Now, these are protected by federal law. The Financial Administration Act, Section 67, that says that you cannot assign a crown debt. Now, a payment to a veteran who has been injured in military service is certainly a debt repayment. It's a replacement for a lawsuit in tort. It's a capital payment. Now, if you're getting a capital payment for a personal loss, that is not family property. That's individual property, because your body is your individual possession, your property. That's why a tort law, you get paid a capital amount to replace your capital loss that you personally suffered. Now, this is a political minefield, even though I'm trying to explain why I'm in favor of the law being obeyed. Who wouldn't? But some people could think that I'm siding with one person, the man or the woman, against the other, when that's not the case at all. I had that very thing said to me. In fact, I was going to go on to another topic, but I was trying to help a veteran from Ontario who was a firefighter. Now, when he was in the military, they gave him the wrong size boots, and his feet got hurt. He ended up getting a pension, and they included that in his divorce as income. So I called his member of parliament to explain how this was absurd, and I got accused of being misogynist. This was something to help the man against the woman. And I gave Buddy a 15-minute lecture almost, I'd say, of don't you dare say that I'm trying to help him out just because he's a man. This is about the law. Now, I didn't realize until later that the member of parliament staffer I was talking to was the Minister for the Status of Women, so maybe they were really sensitive on that topic, when all I want is that the person be treated fairly within the law. That's it. And in particular, in his case, the Pension Act, Section 30, says that nobody can touch the pension. I don't care if it's a court order from a provincial judge. Section 12, I believe, of the Statutory Instruments Act says that judges are required to take judicial notice of federal law. Now, Pension Act Section 30 says that the Pension Act pension is not to be intercepted at all, ever. So, number 301. Now, this is more back in my bailiwick. It's about administrative services only. Insurance policies violate utmost good faith in a prima facie, that means on its face, manner as the indemnity of the underwriter. Identity, my mistake, my eyes are going to get blurry as I look to the side with my bifocals here. As the identity of the underwriter as the employer is hidden. Now, you take Manulife. On paper, it appears that they insure the Service Income Support Insurance Policy 901-102. Now, if that was truly the case, then Manulife would get the premium, and that would be the compensation for it to take the risk of property loss. Now, why I'm saying it in that manner, I was looking at a case from 2005 called Summersall versus Friedman, Supreme Court of Canada, 2005, and the judge said, a really nice quote, without being cynical, I presume the premiums that the insurer accepted is adequate compensation for taking the risk of having to pay the insurance. So, who gets the money? Okay? Is it Manulife who gets the money? Or is it the government of Canada? You see, Manulife doesn't underwrite the policy. So basically, that means the government of Canada sold us a long-term disability insurance, but they appear to have an insurance insured underwritten by Manulife. But if that was the case, then Manulife would have got sued, not the government of Canada. The government of Canada, in the Manouche case, would have sat back and said, good luck, Manulife. That's your problem, not ours. But instead of that, the government of Canada got sued, and Manulife said, good luck with that. That's your problem, not our problem. We only administer the policy for you. Now, for some unknown reason, I can speculate, but for some unknown reason, the government won't admit that Manulife is only the administrator. But it has serious ramifications. The first thing that I would say is what I was mentioning here. Every contract that is negotiated has an implied duty of good faith. Now, that means you can't lie, steal, cheat, fraud. You have to be honest when you're dealing with someone in a negotiation. But a contract of insurance has a higher duty called utmost good faith, and I don't recall the Latin phrase. I'm not going to even try. But utmost good faith is exactly what it says, on the part of both the insured and the insurer, by the way, not just one of the two. But I could argue, because it just popped into my head, that the insurance is the expert, so to speak, so they ought to have a bigger burden than the insured person. Right? It's almost like a fiduciary duty, if you ask me. In fact, I've read a case, I gotta look up the reference, but insurance has been described as semi-fiduciary. Now, reminder, fiduciary means you had to act in the other person's best interest, not your own. Now, if you start off by lying about the identity of who does what in an insurance policy. So the government of Canada is, and I hate to use this word, the employer, because soldiers are not employed, they are serving Canada. There is no union, there is no contract. There's an implied contract. You might sign something, but it's not a contract where you negotiate things. You can't go in and say, I don't want to get paid as a private or a second lieutenant or something. I would say it's an adhesionary contract. Now that's a take it or leave it contract. So the only negotiation is, will you take it or will you leave it? But the thing is about the Service Income Support Insurance Plan, on paper it says that the Chief of Defence Staff is the policy holder and manually is the insurer. Now, that's two lies right there, okay? Because according to the Manouche class action, Manulife is in effect a stranger to the policy. Now, a stranger to the policy is someone who's not party to the agreement. So the judge said that the de facto contract was between the Canadian Forces member and the Chief of Defence Staff. Now, I disagree. Again, that makes me sound pretentious, but the Chief of Defence Staff isn't the government. You know, he's not elected. They're appointed by the Minister of National Defence. So I would say the government of Canada is the insurer, not the Chief of Defence Staff, although they might be looked at as interchangeable. Okay? So, and I believe this might be why the Chief of Defence Staff took over effective control of CISIP in 1st of March 1990. Now, somewhere between then and 2019, Treasury Board took it back over. Because on the 1st of April 2019, the National Defense, Department of National Defense, took it back over. So this is one of the topics I've been using in the past, that the Service Income Support Insurance Plan Policy 901-102 is sort of like a hot potato. In 1982, Treasury Board Secretary took over the policy, I presume from Maritime Life, who had the policy from 1969 to 1982. And between 1982 and 1990, well, that was Treasury Board, like they said. So then the Chief of Defence Staff took it over from them, I guess. I think this has to do actually with the fact that non-public property cannot be administered by Treasury Board. So that's Section 41.3, I believe, of the National Defence Act. So anyway, you're starting off on the wrong foot when you lie about your identity. That's what I'm trying to say. So if it goes to court one of these days, either me or somebody else, you'll point out to the judge that these people are not acting in good faith or utmost good faith, and therefore we would like you to rule in our favor, because you can't trust these son of a bitches. I don't think there's anything I said that was wrong there, because it's kind of like that Putin son of a bitch. You can't trust anything they say in Russia. So, you know, why would you believe that, like, any deal you made would be worth spit? Anyway, number 302. It is common sense and efficient to only certify disability one time in the case of the government, who has a duty to minimize taxation for its citizens. I think this is a perfectly good point, and I just wrote an email to the Royal Canadian Legion asking for their assistance on a bunch of issues, and that was one of them. It's common sense that it would be less onerous on the taxpayer if there was only, say, one certification of disability. And I explained that there are 3 occasions that I know of, and there could be more, where the Canadian Forces certifies disability in service, and that is for if a reservist is hurt on duty. Compensation and benefit instructions 210.72 is about reserve force compensation, and the Canadian Forces has to decide if the reservist was injured on duty. The second one is another one about reservists, and in CISIP Policy 901-102, in the division about reserve force long-term disability, it says in section 41A3 that you have to be injured in service or you don't get your insurance. Now that's a violation of the common law, but for now I'll gloss over that and continue on to the third reason, the third instance of where the Canadian Forces certifies disability in service, and it's the utter bullshit put out by the Minister of National Defence at the time, Peter MacKay, in 2009 or so. And they said, you know, when a Canadian Forces member is injured in service, we're going to refund 100% of the premiums they paid during their career. Now, I don't think anybody ever heard of that because I don't think it's really a thing. I think what they were doing was trying to equate CISIP and paying 100% of the premium instead of 85% of the premium with workers' compensation, where the employer pays 100% of the premium for the insurance you get. However, the problem with that is that even if they paid 100% of the premium, it's still earned by the Canadian Forces member. Now, if I get the government to pay something on my behalf to some other third party, that's still part of my pay. I still earned it. The fact that the government physically pays it doesn't matter. Now, it does matter for taxes, because if you buy an insurance policy and you pay all of the premium instead of the employer paying part of it, well, you get tax-free insurance if you become disabled. Now, what the government is ignoring is the fact that I just said, which is common sense, that even if the employer pays part of the premium, it doesn't matter because I earned it, it's my payment. So if I pay 15% off my check by payroll deduction, and they pay 85% on my behalf, then I paid 100%, which if you become disabled and you get the long-term disability insurance, you have to get it tax-free. One of these days, they'll have to pay us all back for taxes. Okay, carrying on with the next one. Number 303. Power can only be exercised when the person wielding power has the authority to do so, which is common sense. Now, an example of that would be if the government wanted to make, the federal government wanted to make about property and civil rights, like pensions or insurance. Well, Constitution Act Section 9213 assigns that jurisdiction to the provinces. Now, I don't know why I, as a layman, I'm not trained as a lawyer, I've just done a lot of legal reading. Why is Captain Retired Matt Edwards pointing out that the government has violated the Constitution Act? Don't they pay Department of Justice lawyers to make sure that they don't step on their own dick like that? You might say, I mean, the government never do that. Well, that's not really true. They set up the old age security first, and it was determined to be unconstitutional. The employment insurance plan was set up first, and it was determined to be unconstitutional. And I believe these were what's called reference questions, when the government refers its own case to the court to get a decision. Now, that's one of the things I'd like the government to do on certain things. Like it could do a reference question about what is the purpose of Pension Act Section 30, Canadian Forces Superannuation Act Section 83, Canada Pension Plan Act Section 65.1, Employment Insurance Act Section 42, Old Age Security Act Section 36, Veterans Wellbeing Act Section 89, Public Service Superannuation Act Section 1010, RCMP Superannuation Act, something else, I don't remember. These are all laws that prohibit the interception of the payment of a crown debt to someone the government owes that crown debt to. Now, how do I know that? Because I've read cases. Marzetti versus Marzetti, Supreme Court of Canada, 1994 divorce case. There was a tax refund. the guy went bankrupt. There was a fight between the bankruptcy trustee and the income maintenance, whatever you want to call it, the person looking after the divorce money. And they wanted to take the refund, and both of these two agencies ended up fighting about who would get the money. And it didn't matter because the courts got it wrong. The person's supposed to get the money back. It doesn't matter about who gets the money, because they said there are two. The only way that a federal crown debt, and this was an income tax act refund, so they said, well, you had to see how much taxes were owed, and then if there's any credit, any money left, then you had the problem. But before that, I mean, he might not have enough taxes on file to satisfy his tax debt. But after that, there will be a crown debt payable from Canada Revenue Agency to the individual. So they said there are two laws, two ways that this can happen legally. But Parliament has to put into the specific law that forbids the interception. For example, Canadian Forces Superannuation Act, Section 83. So after they put GAP into place in 1982, they put an exception to the you can't touch this money rule into the Canadian Forces Superannuation Act, and they said subject to the Garnishment, Attachment, and Pension Benefit Division Act and the Pension Benefit Diversion Act. No one can touch this money. So when Parliament puts a specific exception in the specific law, that's the only time that a crown debt can be legally intercepted. So, is the Canadian Forces pension, is the Pension Act pension, is Veterans Wellbeing Act income replacement benefits, are those all protected by law? That could be a reference question. The answer again is in previous precedent. 1985, Beattie versus Ladouceur, Ontario Superior Court. A lady was owed $300,000 in a divorce. She couldn't get the money any other way, but he had left the country. So she went to court, asked for his Public Service Superannuation Act pension to be liquidated in a receivership, and then she would get her money. The Department of Justice for Canada intervened in that case and presented an unshakable 100% ironclad argument to the judge. Your Honor, if you rule in her favor, you will be asking the Government of Canada to violate the laws that it wrote to forbid the interception of these crown debts. So we don't have to go to court, really. There has been a precedent already. See? So this is what pisses me off so much about this shit. People tell me this is only my opinion. Well, no, the Department of Justice, they went before the courts and they argued quite rightly that when the government makes its mind up, and we elected them to make laws, it is not up to the courts to overrule our elected lawmakers. Now, there are some exceptions. Sometimes a court can read into the law something the government obviously forgot, and sometimes they can read out of the law something they shouldn't have put in there in the first place. But those are the two exceptions. Ordinarily, we don't have people that are appointed as judges. They're not supposed to make laws like statutory laws. They make precedents, which is case law, yeah, but not, statutory law. Now, that's it for my points here. What I was going to talk about now, and I don't think I talked about it last week, but there was something I was looking up because it's been bugging me. There's a veteran asked me to help look into the estimation of his Canada Pension Plan Disability by Manulife. So let me get that up here. I put up my Facebook for a change tonight, and I'll see if I got a picture or two there, and see if I can read it directly off. If I ever gets this to work properly. So, estimation is when, and as I understand it, usually it's when you have a reluctant person on long-term disability that doesn't want to apply for Canada Pension Plan Disability. So the insurance company puts pressure on that person by estimating the Canada Pension Plan Disability, and therefore they are experiencing financial hardship. That's what the Canada Pension Plan Disability Report in 2003 called it. And they said it was unconscionable. Now, I agree. Unconscionable means shameful. Nobody should have to go through a financial hardship while they're, waiting to see if they get approved for Canada Pension Plan. That's just on general principles. Now, the thing is, there are a bunch of different reasons why this is terrible. The approval rate for the Canada Pension Plan is 35 to 40%. That's pretty low. Now, if it was 100% guaranteed, that could change people's opinion about should you force people to apply. Now, then there's the Charter of Rights and Freedoms. Section 2, I believe, is about freedom of conscience. Now, freedom of conscience means you're supposed to be able to act however you feel, whatever you think is right. Now, there's a caveat there. You can't do whatever you want if it infringes on somebody else's rights. But ordinarily, you're supposed to be able to choose how you live your life. But the stupid estimation forces you to apply for Canada Pension Plan, which is something that you might not want to do. Maybe you don't mind. But most people might not like to be ordered to do something for somebody else's benefit. You're not doing it for your own benefit. They're going to claw it back. That's why they want you to apply. Now, I'm trying to remember. Oh, the other point, it's related in a way, but it's the other point from that report I was going to mention, is that they also found the problem with the clawbacks from the Canada Pension Plan if it gets approved. If you get approved for a Canada Pension Plan and the people then take the money into account, insurance companies usually have less than the real cost of inflation allowance, cost of living allowance. It's called COLA. So they said something that I don't know if I got the idea from them or if it's just similar thinking, but I've been harping for years about this, that if you had a year where you had 10% increase in the cost of living because there was high inflation, the Canada Pension Plan, the Old Age Security, the Pension Act pension, all get full indexation, so they would get an increase of 10%. Now, if you're on the Service Income Support Insurance Plan, then you would get a maximum of 2%. Now, if they're going to claw back the full increase on the Canada Pension Plan or the Pension Act pension or the Canadian Forces Superannuation Act, that means your long-term disability goes down more than inflation. This is evil. You're putting somebody on the steady decline into poverty. It's crazy. Now, as what looks like it would be, trying to think of a word like a lip service, I guess, to that problem, they put into the Service Income Support Insurance Policy Section 24B, which says, in effect, that if you get approved, a clawback of something, the cost of living allowance on the clawback amount shall not be considered income for clawback. So that means, in layman's terms, or to put it differently, that if you got approved, say, for $1,000 a month Canada Pension Plan Disability, then until you die, they are only allowed to take $1,000 into account because they can't take the economic increase for the Consumer Price Index on whatever they're clawing back. Now, I happen to know that this is something they ignore all the time because I called them out on it about 6 or 7 years ago. Now, if I didn't see it before, and that wasn't why I called out Manulife, then seeing that and the government actually agrees with me is a good thing for me, at least. It makes me feel validated. Okay? But, as I said, I'm just going on here with no script, but I recently, because I'm so triggered by this, I've been working the phone a bit, and I haven't been doing that in years. And I called the human something, whatever it is, HUMA is the name of the parliamentary committee. First I tried the chairperson, didn't get through, so I called the vice chair, and I did get through. So one of the points I made to the staffer there is I said, listen, back in 2003, when the Canada Pension Plan Disability Report came out, that's called Talking to Canadians, they said that estimation was unconscionable, which I presume means shameful. Yet here I am, 20 years later, talking to the current HUMA committee people, and you never even tried to fix the problem. I got a problem with that. The government has known about the problem for 20 fucking years. We should have the right to expect this to be fixed. No, don't think I'm wrong. I said, furthermore, I don't know how widespread this problem is, but I have been a veterans advocate for a while, and people are getting forced into applying for Canada Pension Plan Disability when they do not meet the legal requirement as set out in law. So you need 4 out of 6 years since 1998. Prior to that, it was 2 out of 3 years. And now you need 4 out of 6 years. Yet, Captain Denis Ouellette, one of the veterans I've been trying to help, he was medically released after serving from 1978 to 2004, 26 years. So because of the rules, as I understand it, he had until 2006 to apply and get approved for the Canada Pension Plan Disability. Explain to me then why Manulife, who was the administrator of the Service Income Support Insurance Plan Policy 901-102, explain to me how they sent him a letter in 2016 and said, Captain Ouellette, we want you to apply for the Canada Pension Plan Disability because we see that you are eligible. No, he's not. He's not. How can they say that he's eligible when it's 12 years after he was medically released and 10 years after he could last get it? So why are they making people apply for nothing? You see, it might not be for nothing, because I think there is, and he told me just today in a message, he said he's pretty sure it doesn't have anything on paper, but they said to him that there was some kind of an arrangement with Canada Pension Plan that he would get approved even though he didn't satisfy the legal requirements. Now, every politician that I spoke to about this, not them, but their staff, of course, everybody agreed that this wouldn't be fair, that it wouldn't be fair to disobey the law. Now, I said to the people, and they probably agreed even if they didn't say it out loud, I said, if this was really to the benefit of the veteran, I don't think me or anybody would complain about Canada Pension Plan approving them, even though they didn't have the legal requirement. So nobody would care if this was a help to the veteran. But I said, it's a liability. If you get approved for the Canada Pension Plan Disability, you will probably end up, if you have a Canadian Forces pension, getting a bill for bridging. You will probably get a bill from CISIB if they don't get the payment directly from Canada Pension Plan. You'll get a bill from Manulife. You might get a bill from Veterans Affairs Canada if you've been injured in service, and that would be the triumvirate, as it's called, the trio. You get $1 from Canada Pension Plan and you owe $3. Now, there's 2 components of that, I told them. There's the current year payment that you lose money off, and there's the 15 months retroactive period for Canada Pension Plan Disability, which often, almost every time, ends up in a lump sum, And Manulife, bless their hearts, they say, to make things easier, you can send us a check. Well, listen, why would we have to send Manulife a check? We don't owe Manulife a cent. If we owe anybody, it will be the government of Canada. Now, while I'm on that topic, because that is the rant of today, I've come across a couple of veterans that haven't signed the irrevocable consent form, and I've come across several veterans who have signed the irrevocable consent form. Now, the irrevocable consent form is something that raises the hackles on the back of my neck, because we should have the choice whether or not to do something. And irrevocable consent means I can't change my mind about taking back my consent later. Based on that, I refuse to sign it. When I apply for Canada Pension Plan, I apply for the Canada Pension Plan, but I didn't agree to send the money to Sun Life. Now, on that irrevocable consent form, it says who is the insurer. Who should we send the money to? Sun Life claims that they are the insurer, and the government of Canada would have sent them the money had I signed it. Manulife puts down their own name as the insurer. But recall the Manouche case. It wasn't Manulife. That was the insurance underwriter. It was the government of Canada. So if anybody has the right to get the money directly from Canada Pension Plan, they should put His Majesty the Queen on it now. The King, sorry about that. But it could have been before Her Majesty the Queen as the insurer. But no, they lie on an official document that has money diverted from our pensions to somebody else. Now that's the purpose of all of those prohibitions that I mentioned earlier. That's a crown debt payable to us because a pension is property. When you serve, they take money off your check and they bank it for the future. That is your property. That's not the government's property. That's your property. Now, when you get your pension, I'm talking about retirement pensions, not disability pensions. When you get your retirement pension, you're not getting income. You're getting a return of your contributions. You're getting your property back. It's almost like buying an RRSP, a registered retirement savings plan. You make a chunk of money, you put it away every year. When you get out, you buy an annuity from the insurance company, maybe. So you could say to them, I have a couple $100,000, I want to buy an annuity, and they'll say, we'll give you this much per year for this many years, and here you go. Now, it's a gamble for them, because if you live longer than they expect, you make money, and if you live shorter than they expect, then they get money. But either way, they get money because they get the lump sum. They get the chunk of money that you give them in order to get an income. But you buy it with a lump sum, which is your property. So you get the right to get future payments from that single payment. So it seems to me that a lot of people are mixed up about some things. They think that pensions are income. Well, they're paid regularly, which is what income is. They were income in the past. But that's true for all property. You get a job, say with a private employer. You sign a contract, and in exchange for your time, you get paid. Now, everything that you get paid is your income. So you could say that your pension contribution that they pay on your behalf is income. Your Canada Pension Plan contribution that the employer pays on your behalf is income. The employment insurance premium paid on your behalf is income. The long-term disability payment, like the government pays 85% on paper for the SISA policy, that is income. Now, with that in mind, because of the way my mind works, in 2013, CRA decided that it would tax any amount that the employer paid as a portion of a long-term disability type program. So obviously the government agrees that that is income. In fact, not toot my own horn, but I kind of am, I guess. Back in 2014, when I was telling them to fuck straight off that I shouldn't have to pay taxes on my two types of insurance, my CRA's Sun Life and my Manulife military insurance, I said, listen here, instead of taxing the disabled and gouging us for taxes, why don't you tax the premiums? That is really income. The payments we get after we're disabled, that's not income, that's insurance proceeds. But when we were healthy and working, we were getting a portion paid by the employer. I said, and this is income. You want to choose where to tax that. Now, I had a hidden agenda, or at least it might not be obvious to everybody, but you can't be taxed twice. So if they charge taxes on the premium, they are not allowed to charge taxes on the insurance proceeds. That is the rule. Landry Tax Code of Canada, 1998. So, because Canada has a policy of not having double taxation, that is the way it works. The same thing applies to pensions. If they charge taxes on Canada Pension Plan taxes, contributions, and Canadian Forces Superannuation Act contributions, yes, you'd have to pay taxes in the present. But when you retire, you would get tax-free pensions. because you can't tax something twice. Now, if you pay money at contribution or when it's invested in the pension, then when you take it out, you don't pay taxes. So the opposite is true. So if you pay taxes on the end when you withdraw it, then you don't pay taxes while it's vested in the pension, locked in, or when you contribute. Now that's the reason why they do that. Now I have this new theory I came up with not long ago. And I believe we're being screwed on taxes based on the fact that whatever amount the employer pays on our behalf is our payment. So that we are actually only getting half of the deduction that we ought to get. So for the Canada Pension Plan, if they took $10 or $100 off your check and you could claim that on taxes, you ought to be able to claim $200 if it was $100 that they took off of you and the employer put $100 with it, because the employer pays on your behalf. So you really had a $200 contribution, which means you should have had a $200 contribution towards your tax deduction. I think it's a perfectly good argument, and they can't disagree, because that's the way it works when somebody pays something on your behalf. Cunningham versus Wheeler, Supreme Court of Canada, 1994. IBM versus Waterman, Supreme Court of Canada, 2013. Those are my citations. I know my shit. You can think I don't, but I do. What they're ignoring is common sense. Okay? Anything paid on your behalf is the same thing as you paying it. If I gave you money to pay to someone else, it's not that person paying it. It's me. I asked him to be an agent. To be, pass the money out. You know what? It's really hot here in Newfoundland right now. We're not used to the heat, and I'm getting a bit tired and bleary-eyed, so I'm going to call her quits there. It's about 45 minutes. That's not too bad. But in the meantime, I am working this, trying my best as one person to try to get this fixed, trying to educate people about what should be happening. Call members of Parliament like crazy. I was talking to MP in McDonald today, his office in Newfoundland, and I explained what I was doing. I told him I was going to try to tell the lady I was going to try to contact all the Newfoundland members of Parliament so that they're aware of when a constituent has this problem, because it's not just us, me, or this lady named Ashley, but we all face this indignity, this atrocious, this horrendous action. Imagine, like I said to him, I said, listen, I keep saying him, her. Imagine you're a soldier. You agreed to serve Canada with unlimited liability. Now, if the Chief of Defence Staff, who is the head of the military, orders the military into combat, and it goes down the line till it gets to the section commander eventually, and you go into combat and you become disabled. Now, you were doing this on the orders of the Chief of Defence Staff, but the Chief of Defence Staff is also the underwriter for the Manulife long-term disability policy. So because of that, we have a situation where Manulife, who is the agent for the Chief of Defence Staff, they order a person who is disabled in service for Canada, and they're ordered to get the Canada Pension Plan Disability to save the Chief of Defence Staff money on their long-term disability insurance expense. This is like, I would call this a crime. I would call this breach of trust by a public officer, Section 122 of the Criminal Code. And because of the conflict of interest, the bias, like if this was Manulife acting on its own behalf, I couldn't allege that. I couldn't state that. But because Manulife is acting on behalf, the orders of its employer, so to speak, then the one that has to wear this is the one who ordered it. Now, whether they might say we didn't order this, but they also can't say they didn't stop it. Even though, and this is where that report from 2003 comes in, even though it's a notorious fact, a public knowledge item, that the government of Canada said that it was unconscionable, which means shameful, for insurance companies to put financial distress on disabled people while they wait for their Canada Pension Plan Disability to be approved. So now why should the Chief of Defence Staff make a profit from the former soldiers that were under his command? Now, I'll leave it on that note, but I think people should agree with that. I can't see anybody who would disagree. Thanks for watching. I'll see you next week.